Loss of rights due to felony conviction takes many forms. In the United States, this includes voting disenfranchisement, exclusion from jury duty, and loss of the right to possess firearms. United States disenfranchisement. In the U.S., every state with the exception of Maine and Vermont prohibits felons from voting while in prison. 9 other states disenfranchise felons for various lengths of time following the completion of the probation or parole. However, the severity of each state's disenfranchisement varies. 1 in 43 adults were disenfranchised as of 2006. The issue of disenfranchisement gained awareness in 2000 after the excruciatingly close election, wherein 2% of the voting age population was prohibited from participating. In that election, George W. Bush won Florida by 537 votes. However, 31% of black Floridians were denied the vote due to disenfranchisement. Given that African American voters are typically Democratic voters, it was argued at the time that their exclusion decisively changed the outcome of the election. In Reynolds v. Sims, the court ruled that the right to vote is a fundamental right, establishing a strict scrutiny test. Further, the 14th Amendment guarantees equal protection of the laws to all persons. However, Section 2 of this amendment allows states to remove voting privileges from anyone who has participated in rebellion or other crime. Quote, a 1972 SCOTUS ruling found that this article applied to disenfranchisement of ex-felons. The Civic Participation and Rehabilitation Act, allowing for ex-felons to vote, has been introduced at the beginning of every legislative session since 1994, but has never made it to the floor of Congress. 2 states, Kentucky and Florida, continue to impose a lifelong denial of the right to vote to all citizens with a felony record. In the absence of a restoration of civil rights by the governor or, where allowed, state legislature, Florida law is somewhat unique, in that the individual must be pardoned by the governor and a majority of the publicly elected state cabinet. Felon jury exclusion. The lifetime exclusion of felons from jury service is the majority rule in the U.S., used in 31 states and in federal courts. The result is that over 6% of the adult population is excluded, including about 30% of black men. Felon jury exclusion is less visible than felony disenfranchisement, and few socio-legal scholars have challenged the statutes that withhold a convicted felon's opportunity to sit on a jury. While constitutional challenges to felon jury exclusion almost always originate from interested litigants, some scholars contend that it is the interests of the excluded felons that are most directly implicated. Yet attacks on these blanket prohibitions levied by excluded felon jurors have failed consistently. The United States Supreme Court does not recognize the right to sit on a jury as fundamental. It has been pointed out that, although lawmakers assert that felon jury exclusion measures protect the integrity of the adjudicative process, as felons lack the requisite probity to serve on a jury and are inherently biased, many of the states subscribing to this practice allow felons to practice law, but that is a double standard only if it is presumed that those who judge the arguments of both sides in a case are allowed to be as biased as those arguing for each side. The U.S. Department of Justice has argued that felon jury exclusion laws do not discriminate against the disabled because there is no evidence that drug addicts as a class are convicted of felonies in any greater number than other classes of felons. Loss of right to possess firearms. Felons are regarded by the federal government and most U.S. states as being prohibited persons under U.S. law. It is a Class C felony punishable by up to 10 years in prison. This has been litigated before the Supreme Court. However, the court upheld the regulation. In other countries, Canada, an equivalent under the country's criminal code to a felony is an indictable offense. Any person convicted of an indictable offense may lose some privileges, such as the ability to own or use a weapon, operate a motor vehicle on a public highway. Any person convicted of an indictable offense in which he or she used, or threatened to use, a weapon will lose the ability to own or use any weapon for a certain period of time, if not permanently. The ability to obtain a driver's license can also be lost, in some cases, for a very long time. Upon conviction for certain indictable criminal driving offenses, among them impaired driving causing bodily harm or death, dangerous driving causing bodily harm or death, any non-citizen can, after serving a custodial sentence for an indictable offense, be ordered removed from Canada, and will have to, if removed from Canada, successfully be deemed rehabilitated or apply for rehabilitation, to be able to re-enter the country. Generally, any non-citizen convicted of a criminal code offense to which he or she was sentenced to life imprisonment will be permanently barred from entering Canada after being deported. United Kingdom. Within the UK, criminal law is primarily a matter of the four constituent countries. Like in Canada, the term indictable offense is used in lieu of felony. After a conviction for an indictable offense, an offender can, in some cases, lose the ability to keep or obtain a license to drive a motor vehicle, the ability to work with children, the ability to live in the UK,